You live from inside the BTL headquarters here in Belize City, where the company has called a press conference to address issues pertaining to severance payments. And so we're going to take you over to that press conference at this point in time. You ready to start? One, two, three.
Good morning, everyone, and thank you very much for joining us today. We want to welcome you to this BTL press conference, which is also being live streamed on DIGI's Facebook page. So we want to extend a warm welcome to everyone viewing us online today. My name is Amaris Leal. I'm the Senior Marketing Manager at Digi, and I will be your MC for this morning's press conference. Today's press conference is to provide an update by BTL on the matter of severance. We want to extend a special welcome to members of the head table who are BTL's negotiating team with the BCWJ. First, Ms. Kendra Santos, who is our Chief Human Resources Officer. We also have here with us today Mr. Killer Awich, the Internal Legal Counsel and Regulatory Affairs Officer, and also Mr. Ian Cleverly, who is the Chief Finance Officer. We also want to extend a warm welcome to all the media present here today and everyone watching us live as well. Before we begin, just a few housekeeping matters. We kindly ask that all questions remain strictly on the topic of severance payments. Any questions of this topic will be noted, however, we are unable to address them at this time. Moving to today's agenda, BTL will deliver its official statement on the matter, a copy of which will also be shared with everyone via press conference, press release following the press conference. After the statement, it will be followed by a question and answer segment with media present here with us today. I now invite Mr. Killer Awich to deliver the company's statement.
Yes, good morning, ladies and gentlemen of the media and people of Belize. Thank you for the introduction, Amaris. I'm here to provide you with BTL's official press release on an update on the matter of severance to our former employees. So, Belize Telemedia Limited hereby confirms that all sums awarded by the Caribbean Court of Justice in the case of Irvin Marin and Belize Telemedia Limited have been fully paid. The company also confirms that severance payments have been made to former employees who meet the criteria set out in Section 183 of the Labor Act and whose employment at BTL ended within the past 6 years. BTL reassures the public and former employees that BTL continues to act in good faith and in accordance with the law and with full respect for the rule of law. Based on legal advice received by BTL, certain claims, including severance claims, are subject to 6-year statutory limitation period. By law, interest is awarded on judgment debts for the particular litigants in a claim, and the award of prejudgment interest, if any at all, is within the discretion of the court. However, in the interest of reaching a resolution of outstanding severance claims by statute-barred former employees, BTL took the decision to make severance payments to all former employees who qualify under Section 183 of the Labor Act but are now outside the 6-year limitation period. BTL, as you know, engaged in good faith discussions with the Belize Communication Workers for Justice, BCWJ, in that regard. Despite BTL's best efforts, all negotiations with BCWJ have broken down and have come to an end. Now, BTL wishes to inform former BTL employees that BTL will make severance payments to all qualifying employees pursuant to Section 183 of the Labor Act, even though statute barred by Section 4 of the Limitation Act, plus interest calculated at 6% per annum from date of the CCJ judgment in Irvin Marin and Belize Telemedia Limited, which is November 5th, 2025, to date of payment. And BTL invites all former employees who believe that they qualify for severance payments under Section 183 of the Labor Act to submit their information and details for review by emailing severance@livedigi.com. Now, each submission will be carefully reviewed by BTL, and where the statutory criteria at Section 183 of the Labor Act is met, BTL will pay severance payments together with interest calculated at 6% per annum from the date of the CCJ judgment in Urban Marine and Belize Telemedia Limited to date of payment. BTL further commits that once an applicant's qualifying criteria is confirmed, payment will be made within 15 working days of such confirmation by BTL. BTL confirms its full compliance with the CCCA's judgment in Urban Marine and Belize Telemedia Limited, and BTL continues to approach this matter with the respect for the court and the rule of law. The company expresses its appreciation to past and present employees for their contributions and remains committed to a fair and reasonable resolution. And I want to make it clear that by this press conference, this is in no way any admission of liability by BTL. BTL is not admitting any liability whatsoever, but BTL has made the commitments which I have just stated from this press release, which you will get a copy of. Now, the floor is open for questions, and our team will point out who's given the floor to ask a question, and we will answer your questions as asked.
Thank you, Mr. Awich. We will now open the floor for questions. And when asking your questions, we invite the members of the media to please share their name, the media house that they represent, and to kindly direct all questions to the members of the head table and to keep them on the matter of severance payments. Please, we have a mic that we will be passing around. Thank you.
Hi, good morning. Paul Lopez, News 5. Can you help us to better understand, beyond the legal jargon, that is, what are the qualifying criteria that you kept repeating in the statement?
Well, the qualifying criteria for severance pay and gratuity equal to severance pay are found at Section 183 of the Labor Act. So for severance pay, an employee qualifies for severance pay once they have completed at least 5 years of continuous employment with the employer, and the employer terminates that employee for reasons that do not amount to dismissal, or if the employee retires on medical grounds because after having completed 5 years of continuous employment. And for gratuity equal to severance pay, the employee is required to complete at least 10 years of continuous employment with the same employer, and that employee resigns from that employment after having completed that 10 years of continuous employment. So some of you may know that from the Urban Marine judgment that the Caribbean Court of Justice decided that retirement age at Belize Telemedia Limited, which is 55, the CCJ has determined that that is a termination by BTL. And because it's a termination by BTL which has occurred after the employee has completed at least 5 years of continuous employment, that employee is entitled to severance pay. Otherwise, if you look at Section 183(1), it speaks of retiring at 60. But because the court looked at our retirement age at Belize Telemedia Limited and how that retirement age was arrived at, the court determined that it is a termination without cause by BTL. And as I mentioned to you earlier, gratuity equal to severance pay is where the employee has completed at least 10 years of continuous employment and resigns from the employer.
From the company's study, if one has been done what is the amount of former employees? What number of former employees are due severance or requesting severance?
We're currently assessing over 500 employees, and you have to appreciate that BTL gets requests almost every day, and so the numbers are dynamic. And we're doing our best to process them as quickly as they come. And now people who have worked, now former employees who have worked for us and who left more than 6 years prior, know from this press release what is required of them to get their matter processed by BTL and reviewed and processed by BTL.
You spoke, finally, you spoke about a breakdown in negotiations with the BCWJ. We've heard from them. From the company's perspective, what are the reasons, in your view, for negotiations breaking down in the boardroom?
Well, like every negotiation, if the parties come to an agreement which they both agree to, negotiations break down. So if you remain too far apart and there's no likelihood of you meeting in the middle, negotiations break down.
Or are there specific issues where you both stand far apart or sit far apart around the table on?
Well, let me make it clear that we had made it clear to BCWJ that severance payments to those who qualify under Section 183 and who left BTL more than 6 years prior would be paid. The negotiations broke down in relation to discussions regarding interest. BTL, in good faith, improved its proposals, but those improvements were not good enough for BCWJ, and they were not willing to meet us in the middle.
Thank you. We now move on to the next media host.
Good morning, Marcela Maya from News XTV.
Good morning.
Can you share if you've already quantified for those employees who have come forward thus far and those you're aware of, how much in millions you'll be paying out just for severance and then for interest?
Like I mentioned to your colleague earlier, this is an ongoing process. The numbers are dynamic. We're processing calculations every day. Our HR and finance teams are working continuously, so it's still a work in process. The final figure will be determined once as the process completes itself. Let me put it that way.
But currently, where are you?
Well, I can say it's a significant sum. That is what I could say at most.
Can you share if it's pressure from central government that led you to yield to pay severance, or perhaps the demonstrations that BCWJ has been holding?
Certainly not. You have to remember that BTL is managed by its board of directors. Our board of directors know and understand their fiduciary duties, which include acting in the best interest of the company. And the board, in its wisdom, decided that notwithstanding the limitation period, and even though BTL is not admitting liability, it is in the best interest of the company to settle these severance payments to our former employees who left more than 6 years prior, because these former employees helped build this company and make it what it is today. And the company is in a position where it is able to pay these severance payments, even though the company is not admitting any liability, and even though the limitation period applies. And the company values its position as a good corporate citizen, and if the company is able to meet these payments, the company has decided to pay these severance payments to our former employees. So to answer your question, Marisol, it is not because of pressure from external sources, whether it is from the government or whether it is from demonstrations or from the media. The board took an independent decision which was based on what is in the best interest of the company. And you also have to appreciate that it is in the best interest of these former BTL employees because they won't have to spend money to go to court and pay lawyers. BTL is going to honor these severance payments once our former employees who left more than 6 years prior meet the criteria in Section 183 of the Labor Act.
You had to be moved to that position because this was not your initial position. And do you acknowledge that government officials high up have said before that BTL needed to make those payments?
They have said that, but Marisol, I think I've answered the question that how we arrived at this position we are today. The board determined that it was in the best interest of the company.
Can you explain to me, there was a reference to a case from, I think, 2007 among the 10 litigants who had success at the CCJ. Why would that not indicate that you must pay beyond the 6-year limitation period?
In any claim or defense which you put before the court, you have to plead every single matter that you're claiming, or if you're the defendant, you have to plead every defense. The court is not going to find a defense for you, and if you haven't pleaded a limitation defense or any other defense, the court is not going to help you in making out that defense. So, to put it frankly, what occurred is that when the urban marine litigation began at the High Court, it was not pleaded, the limitation period was not pleaded, and limitation was never an issue before the High Court. It was never an issue for determination by the Court of Appeal, and it was never an issue for determination at the CCJ. That is why someone who sees, that is why a former employee or whose employment ended more than 6 years prior was still awarded the severance in CCJ judgment in urban marine.
And you were citing that limitation period because of the large number of former employees who came forward afterwards?
No. As an attorney, you always have to put your client's defenses forward, and our external advisors and myself advised on the limitation period, and it is only right that the board sees or reads our advice and decides what we should do based on that advice. So it's not because of the large number, it's because the limitation defense is available, and the company has a duty to put forward every defense available to it under law.
And then can you share how much has been paid thus far in legal fees regarding the severance matter?
Our chief financial officer would be in a better position than me to answer that.
So in regard to legal fees, they are a substantial amount, but I'm prepared to share the number.
The last one I'm going to ask is in relation to this letter we got a wind of that the Belize Tax Service would have sent to Belize Telemedia Limited clarifying the matter of interest. Are there any instances where BTL would have paid gratuity in lieu of severance? Or I can't remember the phrasing, but you understand what I'm referencing? Yes, taxes.
Thanks for the question, Marisol. Yes, so BTL would have withheld taxes based on previous advices from the Belize Tax Services. I think everyone can appreciate that the call for an assessment or reassessment of how the taxes should be treated, and BTL has certainly asked. I know BCWJ, attorneys, many have asked, and so I think based on where we are at this point in time, the tax services had to engage their own legal advices and has now come to a position in light of the CCJ judgment as to how those taxes should actually be treated. So we have met with them. They consequently sent us the letter that you referred to, and we are very clear and guided by what they have said should be done, and we have all intentions to arrange a refund for all of those persons as per the letter, or those instances as per the letter that they have said taxes should not be withheld from interest for any reason, and taxes should not be withheld from those who effectively lost office. So basically what they're saying is, depending on how you exit, they will recognize it as a gain from employment or a loss of office. So if you had resigned or you had voluntarily exited a company, that's tantamount to resignation, and therefore the taxes would be withheld. If you were terminated without cause, if you retired because the CCJ judgment recognizes the retirees as termination, they are saying in those two instances then, you should not tax. So where BTL had initially taxed, we have all intentions to arrange the refund and process it in very short order so that persons could get back their monies.
Thank you, Marisol. We now move forward with the other media host.
Yes, hello, good morning. Jules Vasquez from Channel 7 News. First of all, maybe I missed it, Mr. Witch, but I'm trying to understand the 6% interest seems to be the sticking point. And I am told that previous groups with who were not over the 6-year limitation were paid the 6% interest, thus establishing a precedent. However, as I understand it, the sticking point in the current negotiation with the BCWJ, who claims to represent over 250 former employees, is that you all will not agree or have not agreed to maintain this 6% consistently. Am I right in this understanding?
Well, Jules, first of all, good morning. You have to understand that this matter of severance has evolved significantly between November and February. The company's initial position was, we are going to satisfy severance obligations for those who are within the 6-year limitation period. And if you are outside of the 6-year limitation period, the company would not voluntarily pay any severance. Now, the 6% that was paid to those former employees who left within 6 years, that 6% was arrived at because the company at that point was not contemplating paying beyond the 6 years. Now, you have to appreciate that the company's position has changed since then, and the company is now going to pay severance payments to those former employees who left more than 6 years prior. So the considerations are now very different in terms of interest, because the company has agreed to settle obligations which it has been advised are now statute barred.
So it's an issue then of the global quantum, that really is the issue, the global quantum.
And then I also need to add that interest is not as of right. This interest which litigants get comes from statute, from the Senior Courts Act, and you have to plead it. And you plead it in your claim at the court, and you succeed in your claim, and the court determines your interest under that provision of the Senior Courts Act. So the company paying interest now is actually the company paying beyond what it is required to pay, because these matters have not gone to court. Only the matter of Irvin Marin and his fellow litigants went to court. And that gives you full context as to why.
Okay, so then you all previously paid the 6% for those within the limitation period.
That is correct.
But you have not agreed to pay the 6% outside the limitation period, not so much because of the quantum, the global cost,
Yes.
but you're saying because it is outside the 6-year period. I'll use Creole, forgive me.
Yes.
Unlucky to get this severance in the first place, because really you're outside the limitation period. So if you're lucky to get the severance, then perhaps you should not be so imposing as to ask for interest as well when you're fortunate to be getting the severance. Is that a fair interpretation?
Let me clarify. From our press release, you'll see that interest is going to be awarded, right? I need to make it clear. It's not that BTL is saying you, former BTL employee, you left more than 6 years prior, I'm only going to pay you severance payments and no interest. No, the company has committed to pay severance payments and interest to former employees who left more than 6 years prior at 6% from the date of CCJ judgment to date of payment.
Okay. Okay, and so now, how would you all, if Ms. Kendra or Mr. Cleverly could speak about, what do you feel about the overall tone of the negotiations? I have a sense that things kind of took a turn in the last round, took a turn for the worse. And what is your hope going forward for a efficient and amicable resolution? Or do you still have such hopes?
Thank you for the question, Jules. I'd like to just step back to your previous question.
Please.
I think that the crux of the matter is that both parties said we wanted to negotiate, we wanted to talk. BTL, as Mr. Awich is saying, is not admitting to any liability. BTL is still relying on its advice, legal advices. If the other party is saying, we don't want to go to court, they've expressed that through formal communication, they've expressed that at their press conference, they've expressed that in other interviews that they've done. So we both say we don't want to go to court, which is why when we were asked and it was agreed that we would sit at the table, they recommended, let's go on neutral grounds, and they recommended the Labor Department. So I requested of the Labor Commissioner and her officers for us to use their conference rooms and have the labor officers just be observers to the process, right? So we went there in good faith, both parties. So if we're both saying we're talking, and we're both saying we don't want to go to court, the expectation that we will give and you will get everything that you believe you should get if you go to court cannot be the premise that we're talking, in our view. You can't think that you will end up getting everything that you believe you would get if you go to court. If it is that we're talking outside of court and we want to settle, both parties have to agree to get something and to give up something. That's the spirit in which we approach the discussions. To your question regarding interest, we had a lot of discussion around whether the interest awarded by the court, if you go to court, is applicable or not. We even conceded to the fact that it's not that interest that's applicable on the table. The company is prepared to pay the interest. Given that if you want to talk about cost of living adjustment or the fact that there is some premium, my words, premium if you will, to be given on these monies because they were not paid at the time it was due. And so the company is saying, well, if it is that your argument is that you only became aware of how this severance payment really should be made once and for all, notwithstanding that you've asked for years outside of court, but that the CCJ judgment has clarified it for all and sundry. Then a good marker to start the interest, because you say I could not have reasonably known that I needed to claim within 6 years of leaving. I only knew that this was supposed to be the case November 2025. The company is prepared to pay the interest from November 2025, benchmarking the 6% against interest that was awarded for those who actually went to court. And the court in its own discretion awarded that 6% for them in the as part of the judgment, right? So that's where the marker of paying the interest from November's CCJ judgment and the benchmark of the 6% came from, because we were trying to be reasonable as to what to give with due consideration of some premium needs to be paid. Now, your final question regarding, in our view, why it broke down. I go back to, I'll say two things. I go back to, I think there was an expectation we realized, despite our improved positions and offers along the way, that there was an expectation that, well, we're moving, they're moving, so we could get more and we deserve what the others got from going to court. And I think that fundamental difference in opinion, that you should get exactly what those who went to court get, even though we're not at court and you're not giving up anything, is a big disconnect. And two, I will put it mildly to say that the manner in which we were engaged this last time around, this second meeting, the tone, the spirit, the lack of professional expertise as we would want to see it was what we were engaged with. And we recognize that for those two reasons, being so far apart, you're trying to get the 6% and everything that comes with a court judgment, along with the approach, is not the spirit in which we can reasonably negotiate. And that is why, in our view, for those two reasons, it broke down. And why we're here today, to tell everyone in Belize that the company wants to move forward without delay and settle with everybody in the same manner. So whether you are being represented by BCWJ, whether you write on your own to the mailbox, whether you come through an attorney, whatever it is, BTL's board has approved that we want to pay, and we want to pay in this manner, and we think it's reasonable to give the severance and interest from November 2025, when the judgment was handed down, to whenever we actually cut a check for persons.
Would you, the other side has accused you all of negotiating in bad faith. What would be your response to that?
The response to that is, we do not agree with terminologies, because we watch the news. We don't agree with terminologies of us lowballing and in bad faith. To us, bad faith would have been if we weren't prepared to sit at the table in the first place, if we were not making improved positions. Not once did we reduce our position, not once did we withdraw it from the table, not once did we get up from the table and walk away. Every single suggestion that they made, breakout, how to write our numbers on a paper, everything that they asked, we facilitated. It really broke down because we believe that they wanted to dictate the pace of our strategy and when we put our final offer on the table. When we last met at the Labor Department, the days go by fast, the last time we met this week, last week, we said very upfront early in the discussions, today we will leave our final and best offer on the table before we leave the meeting. But certainly, Jules, during the meeting, and we're talking and we're negotiating in good spirit, you can't decide to tell us when and how to be writing and leaving the best offer. We said before we leave, and that we did. We made our best offer before we left, and that best offer didn't meet anywhere near what they said their minimum acceptance
Increase your
would
best
be.
offer at the end, though.
Yes, we definitely
That's what I'm
did.
told.
Yes, we did.
Mr. Cleverly did,
Yes. Yes.
which they interpreted as bad faith.
Yes, but that's not bad faith in our view.
Yeah,
You see, if we're discussing, if we're talking, and you say, when you come back in the room, put your best offer on the table. That is your suggestion as to how we should do it. We have already set the tone up front to say, before we leave the meeting today, we will put our best offer. We were trying to get them to appreciate that we were moving constantly. Mind you, at this point in time, they had refused to give us a percentage, and we were moving. And so we had to move upwards to make sure that we were calling something from them. There was only one time in the whole process that they actually wrote a percentage and put it on the table. We did 3 times a percentage. So, in bad faith, we cannot accept and agree to that.
I think if I may, and this is my last two, if I may, they have a sense that you all have a green light from the board to meet their expectations. This is how they feel. I don't know, in this case, I don't know what the board's directive is. I signed the confidentiality before I came in, so. But they have a sense that you all are nickel and diming them or shortchanging them when you all have executive approval to go higher, as was shown by Mr. Cleverly's 0.5% bump at the end. So they feel it is bad faith that they're being nickel and dimed when you all have a green light to go higher. And then my last question would be, they want to meet with the board in total, the entire board. Is that something that is even being contemplated? Thank you.
The board has made its final decision regarding the severance payment, and you will get the press release after this meeting we have here with the media. And to answer your question, because the board has made a final decision, there's no need for any further meetings with the BCWJ. We cannot delay the payment to our former BTL employees because BCJ wants different terms. You have to remember, Jules, that not every former BTL employee is writing or requesting through BCWJ. And I could put it plainly and clear to the public out there that after our last meeting on Monday with the BCWJ, my office got a call from one of the persons who was being represented by BCWJ saying, I am willing to accept my severance pay and whatever BTL is offering as interest. You're dealing with real people who are waiting for their monies. They have worked at BTL. They have given their good service. They shouldn't be delayed because one group or section of that group of former BTL employees does not want to proceed towards receiving payments. And also, I think I need to add that in terms of interest, why you hear the CCJ judgment date as the point where we're calculating interest from, it is because November 5th, 2025, the date of the CCJ judgment, is the date from when our former BTL employees who left more than 6 years prior, that is the date when they could, with reasonable due diligence, have discovered that they have a worthwhile claim for severance. Prior to the CCJ giving its judgment, these former BTL employees could not have, with reasonable due diligence, have discovered that.
Thank you.
Thank you.
Yes.
Sorry. No, I think that when we were trying to settle with the BCWJ, we were really trying to do it out of sheer respect that they had a large audience, they were writing, they were well organized, and they were protesting. That does not mean that we weren't getting inundated like Mr. Awich. The HR office was being inundated by members who they represent and members who they do not represent. And out of sheer respect for a process, and we didn't want to antagonize, interrogate that process, we decided let's deal with these persons who have gone publicly first, but the company had all intentions to pay everybody the same thing wherever we landed. We also have gotten requests to say, I didn't even expect interest. Can you just give me my severance? And we have said we need to table it at the board. We have taken this long not because we wanted to just be casual, but there's a process to these things. The judgment came down. Calculations had to be done. Data had to be restored and compiled, and that is still an ongoing process. You have to call board meetings. We have to get legal reviews, sometimes more than one. Right? You have to go through a process, and we know while that is brewing, public sentiment is boiling. But the company cannot be knee-jerking and reacting to every sentiment. We watch your news, we hear the same comments from everyone. But the company has to be prepared to make a decision and communicate same. And we did that in that same order. We did not just send out a press release. The board didn't just make a decision and say, pay everybody. We went to BCWJ. We are satisfied because we were the three who went to the Labor Department. We are satisfied that we tried. And so without delay now, we don't have any legal reviews to go through. We don't have any other things to sort out that we had to sort out December and January. So the company is at a position now that without delay, we would like to get past this. It's in our best interest to just get past this, settle things, and try to move on because we have, despite what many may believe, we have a lot of work in this company to do. It's not an easy job every day, and this is very distracting, so we would like to settle it.
Thank you, Ms. Kendra. We move on with the next media host, please.
Yes, Vice Media, Hilly Bennett. I see the matter of bad faith being thrown around, but I listen to you, Mr. Witch, and what I see is good faith discussions. And even outside, when I look at the matter you explained outside the scope of the statute, a limitation in regards to interest, right? That there was no pleading before the court on that matter, and still the company has reserved its position to deal with that. You explained it, that every issue has to be pled before the court. There was no pleading on that matter. The other thing I want to say, because people have been saying that the delay, the resistance by the company is in regards to protecting the bottom line. Maybe you could just share your view on that.
So the claimants will come forward, and the calculation and the review of their severance and interest is under review. This hasn't been taken as a bottom line discussion. It's been about what's right. What's right for the people, what's right for the employees, and BTL has acted in good faith and is prepared to settle those severance claims. We have not considered this as a bottom line discussion. It's about what's right. And the board have taken a decision that this is the right course of action to settle those claimants. And also, we encourage them to come forward and claim their severance. We are prepared to pay, and we are prepared to pay interest, as been outlined by Mr. Awich, and we applaud people to come forward and claim, because we have acted in good faith.
I have a question. There was a question, it was a comment. My name is William George Sigiri. I represent the Mandala. And my question is simply this. Can you please clarify, right, for those that are within the 6-year year of limitations, will they be getting their interest up from when they were terminated? In fact, let me ask you this. Since you're saying that it is the court that defined that 60 years age limit should have been the retirement age, and that therefore being retired at 55 was termination without cause. You all are saying that up until the court judgment, you were unaware that that is the way the Labor Act should be interpreted, that you were unaware that these employees that left when they reached 55 would actually be entitled to severance, because apparently they were unaware of it. You're saying the BTL management also unaware that they should be paying severance? Is that what you're saying now? And one more thing.
Okay.
I mean, you guys make it sound quite magnanimous that you will be honoring severance payments to people who left, that they wouldn't be able to apply because they're outside the 6-year limit. So if they were to go to court, they wouldn't have a leg to stand on. But my question really is, if they were in fact entitled to severance from when they left the company's employ, all right, wouldn't good faith be to pay whatever interest rate is agreed to from when they were terminated? So that's the interpretation that there is between what the Labor Act says of retirement as opposed to you calling it what the company regarded as just, oh, you retired at 55. But now the court has said, no, 60 is retirement age. So you leave before and they weren't fired or dismissed, then it is termination, and that was implying that severance is required. So it sounds like the company and the employees were ignorant that they should be paying severance. Is that it, what you're saying?
To answer, I'll try my best to answer your question, Mr. Isagir, but in terms of the retirement age at 55 years old, that is, at 55 years old at BTL, that is a matter which the courts themselves have had different views of. There's a judgment, Oscar Gongora, where Mr. Gongora was refused severance by the court because he retired at 55. That was a high court decision, and the CCJ has, as you know, decided differently, that retirement at 55 at BTL, because of how that 55 was arrived at, is a termination by BTL. So, to answer your question, even our respected judicial officers have had differing views regarding that 55, and obviously the employees and employer would have had a different view until the CCJ finally clarified what was the true position regarding 55 years old retirement age at BTL. And to answer the second part of your question, I believe, and we as a company, BTL, believe that acting in good faith is one, as Ms. Santos mentioned, being willing to negotiate, and finally deciding that notwithstanding the limitation period, and even though we are not admitting any liability whatsoever, we are agreeing as a company to pay severance payments to former employees who left more than 6 years prior. I believe that is a very good sign of good faith because, one, you're acknowledging that these people have worked at, rather, you're acknowledging that these former employees have worked at BTL for the requisite number of years, and you're acknowledging that, well, you can't ignore that fact, and it is only right and in the best interest of the company to pay these severance payments. And it is also in the best interest of these former employees because you're saving them the trouble of having to wait several years of going through the judicial system and hierarchy, and you're saving them the expense of having to retain counsel. I believe strongly that that is good faith, Mr. Isegi.
My name is Yaya Marin Coleman.
Good
I
morning, Ms.
represent
Coleman.
XTV. You could just call me Yaya Marin. Come in, married, define me. You keep saying, or all of you keep saying, and my 2 cents is to the insult of Belizeans, that you're acting in good faith. Let me ask you,
Yes.
do you agree that trust is critical for healthy communication?
Yes.
Trust.
Trust
It
is a good thing.
Good,
I could only say at large, trust is a good
Okay,
thing.
good. So, when you went before the CCJ, did BTL say that the severance was a part of the pension scheme? Did BTL say that?
Well,
Is either yes or no, brother? Did BTL say that?
you have to understand that BTL's position was that the pension had subsumed severance, that severance were bundled up within the pension contributions which BTL was making to the pension fund in respect of each employee. And you have to remember that the courts decided against, the Court of Appeal and the CCJ decided against BTL because we were not able to prove that to the satisfaction of the court. Now, you have to keep it in mind that the fact that you're unable to prove something does not necessarily mean that it's untrue. You have just failed to come up to proof required by the courts.
Okay then, brother.
So we lost in our defense.
Okay, brother. So in a cruel, we say fully talk but not fully listen. So bottom line is, BTL said that all the severance subsume me in the payment, in the pension payment. The court say on never prove it to for their satisfaction. That mean on a lose pan the ground. So if then people never gone all the way to the CCJ for make the CCJ rule and say, I know that mischief, then call it. But you refer to section 32. What Section 32 say as relates to limitation when you find out about the mischief? Tell me what you say.
Section 32 was not a part, Section 32 of the Limitation Act was not a part of the litigation in the Marin case. It was not a part of any of the litigations regarding severance and BTL. But that is the provision which deals with disapplying limitation acts, and it sets out different bases on which the limitation is disapplied. One of them is fraud, mistake, and, consumer. It is elaborated there.
So you to say, as a lawyer who's familiar with Section 32, that even though Section 32 say, when they recognize that a mistake has happened, as with the CCJ case, the mistake is BTL say the severance is part of the pension scheme and couldn't provide the evidence to the court satisfaction that they wanted to find out about a mistake. And according to Section 62, that the when the statute of limitations start, that the when the 6 years start, at the point that you become aware of the mistake. Unless I do understand it wrong, but you make I know if I do understand it wrong. Then that's how you go.
You've somewhat described Section 32 and mistake. When it is when with reasonable due diligence you would have discovered the mistake. But you have to remember there's a difference between a mistake and when two parties have a difference of interpretation of a matter, right?
Well, and this is our problem with Nancy. The media could go back and read the CCJ ruling. This is not the CCJ ruling. They're not me to make this up. So from a people's perspective, we find that we're not to be truthful. And that will pass Section 32 in particular. So I just want to make that known very, and then don't come out here like, do we want favor with this press conference? My position is that because of authentic people pressure, make no come out, can knock, dog, holla. Secondly, when one individual write to BTL, because only one out of 274 people write and say they want anything, so respect that one have a human right to do that, but make sure that one out of 274 will be Belize Communication Workers for Justice represent. When one individual write to uno answer them back? Because uno say they can write, I ask if uno answer when they write to
We acknowledged receipt and told them that we're reviewing their file based on the request they have made.
And how long that take?
You have to understand that we have at present over 500 former employees who we're reviewing, and the press release has stated that upon confirmation by BTL, your payment will be ready within 15 working days. I can't tell you how long each specific person's matter takes to review because, some former employees have been here for a very long period before they left, and our HR teams have to look at archived files and locate archived files and also look at the system which the digital system which we have, which has employee information. So it's dependent on employee to employee, but we do our utmost best because we recognize that you can't delay severance payments any further.
Okay,
so we try our utmost best.
Christine Perrott, and give me permission for say this. Send a letter to BTL January 29th and February 18th. I not get no response. I have copies of the letter, just to make you know. And so it's very important, only Korea, because of Belizean people build this company. I want to hear that. And I feel insulted truly as a Belizean because I act like they're not intelligent people that then build this company or else I wouldn't be hired to even sit down here. And I really appreciate if we give more, like, not lip service, but real respect to everyday people, because we got a history of holding power accountable. And then the other concern, I noticed that BTL, only not to follow the CCJ ruling. And I don't know, like, only could contact, like, legal language, but the CCJ ruling said this. How ono, like if one of we just not follow the law and come for a long time, including the Labor Department who not enforce the ruling. So unless I got it wrong, brother, explain it to me. The CCJ ruling on November 2025 say, and then the Prime Minister say, and then the Labor Minister, who the attorney say, isn't the 6% the standard when it comes to severance? I'm asking in the court, isn't the 6% standard?
6% interest is prescribed by the Senior Courts Act, and that is awarded on judgment days.
So what that mean? The question
that means that when you succeed in your claim at court, the court can award you that 6% because the Senior Courts Act has made provision for that 6%. And then the court may or may not give you interest from the date before judgment. It is at the discretion of the court.
So the CCJ ruling never says 6% from the severance? The CCJ ruling did not say that?
We have complied with the order regarding the interest and regarding the severance payments as ordered by the CCJ. You have to remember that in Irvin Marin, the order that was made was in relation to the parties in that case. The order was made against BTL in favor of Irvin Marin and the other appellants in the Irvin Marin judgment.
Okay.
So we have fully complied. All sums under that judgment order have been paid. It is absolutely wrong, incorrect, and false for anyone to say that BTL has failed to comply with the CCJ judgment. That is an uninformed opinion, and it is absolutely false.
Okay, that's what you to say. But not because you to say so, mean that so. They have other legal minds like Glenfield Dennison. You're not the only attorney. That you don't know, and then not because we don't know attorney, mean we don't got common sense and can't think and reason for ourselves. So I tell you categorically that don't know how we receive it. And just to go further, right? Because and again, I don't know other bushla I the land.
Yes.
The 6% to my understanding, the standard for the court when it comes to severance. Are you saying they have to go to court for make the court tell them 6% for uno concede to 6% per severance?
Yes, that is correct.
But uno said they have to go to court for that. Well, then don't go to the CCJ and you said they have to go to court again?
No, they didn't go there. It was Irvin Marin and the other appellants who went.
And the CCJ include a ruling enough for the judgment
Yes,
for the 25th.
and we have
for the 5th.
BTL has fully complied with that
Okay.
judgment order.
Well, then if you want to comply...
I could share the judgment
Okay,
order.
I
with
have
you
the
after-
judgment, but what I
not
ask
the
you
judgment,
is-
the judgment order.
Okay, so
what
I
the
ask you,
CCJ is telling
if
BTL
only
to
in a
do.
compliance, why Ono and this group can't agree then if only in a compliance at the
Pardon?
6%? You just say Ono in a compliance with the ruling.
Yes.
If Ono in a compliance, why Ono and the group have one disagreement over the 6% if Ono in a compliance?
I think we have ventilated how we arrived at
Well,
interest and what
thank-
occurred in those discussions. And I've mentioned it before. I can share with you the
I don't agree with
CCJ's
you.
order after this. You might have seen the judgment, but I actually have the judgment order, and I could show it.
Well, one of the things,
Thank-
this is my
thank you
last,
very
this is my
much.
last point. This is my last point.
Yes.
This is the people's space. This is my last point on the people's business.
Yes.
I just want to bring to your attention because you're familiar.
Yes.
I believe you were the attorney for your father when
Yes,
he
that
went
is
before the
correct.
court, and he also had the 6% on his severance at the time of his termination.
We're here to talk about
I
BTL
don't
severance.
want to talk, but I just to remind you.
But
Can
to
I-
answer that,
Right. Yeah, so Kelaru, can you answer it and then can I just address the last point, please? Go
yes,
ahead.
he went to court and asked for 6%. That is how it answered.
Thank you. So, Yaya, I do appreciate your presence. I know that you represent people very well. I think that we can agree to disagree. I think that what I'm hearing you to say is that the CCJ judgment and the award from that judgment should be carried over to all and sundry. This is where we disagree. Our understanding is that a judgment award is for those who the award is specific to. If others want the same award, they have to go and claim that because the court will look at everybody's individual circumstances. The court will look at whether they were reasonable to have not claimed within the 6 years, so they would have to cross the hurdle of statute of limitation. The court would have to look at how they exited BTL. The court would have to look at all the scenarios. Their scenarios, everyone's scenarios, is not the same as those 10 people who got the judgment from the CCJ. So I keep saying, I think there's a fundamental disconnect as to when we're thinking that the CCJ judgment, an award, is transferred automatically to everybody else who may or may not have the similar circumstance. And so I always get back to, do we want to test that again in court, or do we want to sit down and agree that some things look the same and therefore we can start to talk where we can meet in the middle? Or if we'll both hold our corners, then we should probably go to court to test it and have the court tell us on each count if all these scenarios are the exact scenarios as those who got the favor of the judgment under the CCJ. So I do respect that there's a fundamental difference in opinion. Legal minds differ even, but this is where we're at this point in time. But I do appreciate your stance on it.
Respect, that 60-day ruling was a precedent ruling, but it looked like
Thank you very much. Thank you very much for the members of the head table, all the media present here today, and of course everyone joining us live. We appreciate your time and interest on this matter. This concludes our press conference this morning. Have a good day.
Thank you all.